Good morning, everybody. Welcome aboard. This is the Keeping Your Business Moving session with Solent LEP and Newable. My name is Rob Lutas. I'll be hosting today, doing the host with the most, but with a panel and group of other experts that we will bring in due course. So just a few housekeeping points. If you can hear me and see me, that's great. If you can't, if you could just drop a note in the chat box. So on the right hand side, you will see a little menu. There's a section with chat. If you click on the arrow, that will open up and you can just type your question in there. I just know through experience, sometimes people have some problems with the speakers. If you just go to the sound option on your laptop or your computer, and change that around, and it should resolve itself. But if not, we're ably supported by Hannah, who's on the team, who can take you through any tech questions like that. So just drop a note in the chat if you would. So the webinar will be recorded. So if you do need to follow up and pick up any points that we've covered or missed while you're making a cup of tea, you can go back and grab the recording and look back on this. We don't have interaction in the way of any questions, any live questions through video, unfortunately. So if you do have any questions as we move along the various different sessions, please again use the chat box and we can pick up your questions and we will address those as best we can. If you don't want to alert other participants, just type private before you do that, and we can come back to you individually. So if there's any commercially sensitive information that you don't really want to say about your company or your business or what you do or your customers, just put private in front of the question and we'll make sure that that is kept discreet. So one last point on that. This is we're trying to provide as much expertise as we can through these things to help and guide you through some of the challenges and issues and also some of the opportunities presented through the EU transition. But we have to recognise that it is quite a complex area. And as such, we won't be able to offer you full comprehensive answers to every single question. But what I can say is we will take this away. We will bring this away and make sure that we come back to you with the best possible answer we can, directly or indirectly through our panel of experts. So I think that's okay around the housekeeping. If you just have a look at this, any referrals that we do make to any of our experts, that's entirely up to you to discuss and negotiate if there are any commercial terms. And whilst we really welcome the support of our colleagues from the private sector organisations today, you know, we can't make recommendations because of who we are and what we do through the various different agencies that we work for. So I hope that's understood. So quickly through the agenda, we're going to have a quick overview of what the programme is about and Solent Local Enterprise Partnership from Jane Syme. One other piece of housekeeping: if I or anyone uses any acronyms and you don't know what they are, again, pop it in the chat. So I just see one on there. We see overview of Solent LEP. LEP is a local enterprise partnership. If you don't know what any of these things are, it's completely understandable. Drop a note in the chat box and we'll come back to you straight away and say what they are. We're then going to have one of our EU transition advisors, Ed Marachi, talking through what we can offer in the way of the support from that end, followed by Mark Hampson, who's one of the Department for International Trade advisors, specialising in the marine sector, but based in the Solent area. So Mark will cover what we do from a Department for International Trade perspective. Then Jane Biddlecombe from Paris Smith, talking around the immigration impact and some of the issues around there, followed by Laura, again from Paris Smith, looking at some of the intellectual property, trademarking and IT related impacts of EU exit. Then we have Louise Haycock. Louise is from Froggerman, talking about some of the inbound immigration, so some of the travel related matters that we're likely to encounter, current and future. And then lastly, we have Klaus Anderson from Royds Withy King, and Klaus is going to talk about some of the broader trade aspects. And Klaus has got great expertise across a number of different factors across the EU transition. It'd be great to have Klaus on the panel later on. So that's the agenda. So with that, I'm going to hand over to Jane. Jane from Solent Local Enterprise Partnership, who's going to explain a bit about the programme and a bit about the LEP as well. Thank you.
Thank you, Rob. Morning, everyone. Yes, so thank you very much for this event. Is absolutely useful, I think, at the moment for businesses. So hopefully it will be useful to hear a bit of an overview of the services that businesses in the Solent can access in often challenging times that we're facing at the moment for a number of reasons. Next slide, please. I feel like but the press briefing. Thank you. So I thought the most useful thing to offer today, particularly to businesses that are maybe less familiar with the support available from the Local Enterprise Partnership. Because of the nature of our service, we have to be quite we're quite an agile business support service. It's really important that we're very responsive. So we're shaping the support available to businesses constantly, dependent on what the priorities are, what's happening in the economy at any point. So I thought the most useful thing to do was to just run through a few of the provisions we've had available for businesses over the last year, and just to give you a bit of a flavour of the type of support you may be able to access if you're facing different challenges. So when March happened, 2020, we very quickly launched a number of provisions to try to support businesses through some obviously very significant challenges. The first funding provision that we launched was our crowdfunder Pay It Forward Solent programme. So we did that in partnership with Crowdfunder. It was very useful at that time, particularly for businesses who were trading directly with customers, so B2C businesses who were it had the restrictions imposed. They weren't able to trade at all, and wanted to first of all find some way of generating some revenues and some cash flow to cover the overheads that they were still having to meet, but also to still stay engaged with their customer base. So you were able to set a target to raise money through the crowd, through your network of customers, in return for services, products. So it wasn't a sort of a charitable program. It was you pay for these services, and the incentive is that you will get these products or services at a discounted rate, because we can't always deliver them in real time. So often they were having to sort of wait until that shop or cafe or service deliverer was in operation again, and that worked really well. Small grants, the LEP were match funding the amounts that businesses raised through the crowd. So that was one program that we launched quite quickly, and that's still open for businesses to access now. There were a couple of larger funding opportunities. So the Restart, Restore, Recover Loan Fund, which was primarily to help businesses who either were experiencing delays in accessing the coronavirus business interruption loan scheme and the business bounce back loan scheme. So sometimes they were experiencing sort of fairly lengthy delays, and they were unable to sort of bridge that gap, and we were sort of trying to support with that. And also, some people were had recovery plans, pretty comprehensive, but they didn't necessarily have the finance in place to enable them to carry those out. So we were trying to support with that. The Getting Building Fund was the sort of larger infrastructure projects, and that work is ongoing to try to sort of really stimulate the economy and some projects that are going to have sort of a significant impact on sort of boosting the Solent economy. We had a couple of more sort of geographically specific funds. Again, these are still available to look at for businesses. So you can see on our website all of the current opportunities. So the Isle of Wight Rural SME Fund and the New Forest Rural SME Fund, those are primarily for sort of capital costs and to help businesses with their recovery and the impacts caused by COVID. So signposting is a primary function of the Solent LEP business support team. We do deliver funding programs and business support initiatives ourselves, and we receive funding to do that. But we also play a really important role in signposting out to other key stakeholders across the landscape, as it were. As lots of different people have been, plugging different gaps and trying to sort of cover all bases. We've been doing a lot of supporting of businesses who are trying to sort of navigate the funding available through local authorities. So although we can't impact the sort of the administration of that, we can certainly help people to understand the guidance, what's available to them, and how to access that. There's other sort of types of funding that are more specific depending on the types of projects you as a business are looking to access. So it could be innovation funding, at which point we would signpost out to experts from organisations like Innovate UK, KTN, Green Tech South, lots of different organisations that can help you with certain expertise, UK Edge, depending on what you need to focus on. And we also have a resource that we use to support businesses in finding funding, as well as funding has been quite a big focus over the last year for sure. So Grant Finder is something we have access to. So when you speak to one of the advisors at the Solent LEP business support team, you'll be able to get them to sort of carry out Grant Finder search on your behalf. And hopefully that throws up some results that perhaps we were unaware of. The funding landscape is quickly changing all the time. So that's something that we use to try to stay as up to date as we possibly can with what might be available to you. So that's the funding side of the support we offer. We also are always trying to think of how we can administer support as well as funding, and to give businesses the type of support they need to action and plan. And particularly, even if you're applying for funding, there's a lot of strategic planning that goes on, alongside that, and we want to make sure businesses are supported, comprehensively in a sort of a broader sense. So we are offering a number of different sort of strategic support programs. We started with our Growth Accelerator program, and that was pre-2020 that was launched. So we quickly found in 2020 that the focus had shifted away from growth, which won't be a big surprise to many of you. A lot of businesses were communicating to us that they needed support building resilience in their business, and that's why the Business Resilience Programme came about. But essentially they offer a similar level of support. So we deliver this through BDO, a financial advisory and sort of business advisory firm in Southampton. They offer 12 hours of one-to-one tailored support for businesses to help them with their plans, and to really ensure that your plans are robust, that you're thinking of any opportunities to diversify into new markets, whether that's exporting, as we're sort of talking about today, or whether that's other domestic markets that you may want to explore. And the Startup Launchpad as well is something that you can access if your business has been trading for less than 18 months, and you have at least one trading, one customer, essentially. So you need to already be trading. Those support programs have been very beneficial to lots of business owners because they are so bespoke and so tailored to whatever your needs are as a business. So I want to sort of really emphasize that. Please do get in touch with us. This is funded support that you can access, and usually this level of expertise is is not cheap on the private market, and we really want to make sure businesses have access to that type of support. We also launched a peer-to-peer networking program at the end of last year, at the end of 2020, recognising that businesses had a lot of support to get that would be really beneficial to them from other business owners who were experiencing similar challenges to themselves. Lots of shared challenges across multiple sectors, and plenty of value to be had in facilitated peer networking sessions, and that's going really well. So do let us know if you want to get involved in that. It's going really well so far, so I imagine there will be further opportunities into 2021 to access similar support. And then I've left it to last, but the most sort of relevant to today, the support that we've been shaping around Brexit. There are an array of offerings on the Solent LEP website, so do have a browse through our business support hub, and particularly the Brexit and exporting and overseas trade information. There are a range of there's self-service resources, so our toolkit that you can complete and that can bring up useful resources for you depending on your specific situation and needs. There's information about useful events and organisations that can support you with various things. And also the one-to-one support that's available to you to help you with any challenges brought about by Brexit and the changes associated with it. And that's delivered by Newable, who you'll be hearing a lot more about today. And lastly, there's always access through the Solent LEP to a team of advisors who will support you with any challenge that your business is facing. So we are very, very accessible. There's nothing exclusive about our service at all. We want to speak to you if you're in business and you're facing any kind of barrier that is restricting your ability to grow and to sustain your business. If there's something that we can't deliver ourselves in support of you, or an area of expertise that we don't have, we will find somebody for you that can offer that expertise and that can help. So I just want people to know that you don't have to be isolated and unsupported at a time like this. There are people that you can reach out to that can help you to navigate all of the different support provisions that are available, and we're here to do that. And I think there is another slide, isn't there? Next slide, please. So who can access our support? Really, you just have to be an SME operating in the Solent. So those are the local authority areas that constitute the Solent. And again, as I said, any business in any sector that's facing any challenges that we might be able to help them with. And I sort of covered in my summary that we don't just provide funding. Obviously, we understand that funding has been a big focus in recent times, and as always, but we really recognise the importance of the support that goes alongside that as well, and we offer not just directly delivered support through the Solent LEP, but signposting out to the really specific niche support for either areas of challenge for you in your business or for your specific sector. Next slide, please. So how do you get in touch with us and benefit from all of that support and signposting? So the Solent LEP website is always the best place to start, solentlep.org.uk. Do have a look on the website because there are so many really useful resources on here. The first thing I would do is to top right-hand corner, subscribe to the newsletter. The reason I suggest that is because there are so many businesses that have been looking for support, particularly in the last year. So the most efficient way that we can communicate any launches of new funding initiatives and any sort of support programs is through the e-newsletter. So that's how we'll be communicating with you about those things. But we'll also be making sure all of the information is published on the website and is up to date. So do keep an eye on that. Specifically, I've pointed in the links here to the contact us page, so you can complete an inquiry form that will come through to our team, and you'll be contacted to set up an appointment with an advisor over the phone. And that just gives you an opportunity to speak in a bit more detail about your business and the challenges you face, and we'll go from there with you. The business support and funding, the business support hub, I should say, on the website is where you'll find a lot of the information about the Brexit tools and resources and the support that you can access that Newable are delivering for us, which is really, really valuable to access all of those expertise that you'll find out a lot more about today. And that's about it from me. So thank you very much for having me. I hope that's useful, and please do get in touch with us if you'd like to speak in a bit more detail about the support available.
That's great. Thank you, Jane. Thanks very much for that. And I suppose summarising, there's so much support available. The problem is you know, when we're running businesses like you guys are, and often completely immersed and busy with the day-to-day, trying to navigate through the myriad of support available can be quite challenging. And that's what the Growth Hub is really good, because they probably dealt with businesses very similar to yours with very similar needs, and they can get you right into the right area very, very quickly and make sure that you're getting the right sort of support, the right sort of price as well sometimes. So thanks very much for that, Jane. Next up, we've got Abe. Abe Marachi, I'll do his little brief for him. Abe is one of our EU trade advisors, comes with a huge history of experience working in international banking, and also I think about 7 or 8 years, Abe, you can correct me, as one of our international trade advisors as well. So with that, I'll hand over to Abe, and he'll tell you what we're about as well as far as the EU transition advisor role is concerned. Thanks, Abe.
Good morning. I'm sitting here and wondering whether any of you are fans of escapology. You know, the adventure rooms, the escape rooms that people go as far as Copenhagen or Barcelona to be locked into and then get out of. And to do so, you normally have to solve a number of clues, okay? It's not sort of Houdini stuff in New York Harbor or David Blaine in Tower Hill. It's something that is very contained and which can be achieved and have fun. Now, I only tell you this because last week, a plastic moldings firm near Southampton, the chap was an escapologist, and he said, look, I'm approaching this transition period rather as if it was the challenges of an escape room, and you're going to help me, okay? So I said, well, funnily enough, I have that feeling as well, because the Solent Enterprise Partnership has put together this team under Newable of former international trade advisors and people who've got a certain track record behind them in order to look at those clues with you, in order to do the research that is necessary, the cross-referencing that is necessary. We also do specialist consultations with industry and with chambers of commerce. And at the end of the day, what we can jointly do is develop a plan, an action plan, and at the same time, also try to spot new opportunities for the company in question. I've got to differentiate between our role as EU transition advisors and international trade advisors, which will come next by the hand of my former colleague and friend, Mark Hansen. The international trade advisor is really a concierge service, one that you will have a relationship with, and it will carry through the years on all sorts of levels. We, on the other hand, are troubleshooters, the EU transition advisors. We go into EU regulation skirmishes, we try to help you solve the problem, hopefully do so, and then we move on. And back you go to an international trade advisor if you've got one, and if not, we can point you towards your getting one. So just to give you an idea, the companies that I personally have looked at in the last 10 days have ranged from Italian oil platform workers asking about employment law here in the UK, sellers of vinyl records to Belgium, defense contractors, fencing and hot tub importers and assemblers, America's Cup designers, a life coach, and it goes on and on and on. So it is very important that no company feels that they're alone, because you're not. Frankly, I mean, this is a new bicycle that we're all learning how to ride, all of us. Nobody has all of the answers. And the more we can help one another across all sectors, that's going to be the better to get out of the escape room, okay? It's also important that you know that both international trade advisors and EU transition advisors are people who, just like you, have owned and run our own businesses. And so, you know, we can empathize with you. We've been at the coalface, and therefore we understand your challenges firsthand. This isn't some hypothetical academic paper, you know, that we're writing. We've actually been there, you know, when things have got stuck at customs, when suddenly new tariffs are imposed in some faraway port, etc. So we know what you're going through, and that's exactly what we're trying to solve. As Rob says, my own background is 30 years in major US banks. I've also sat on AIM-listed company boards, also private boards, and I still have an export-import company on the continent, which, like everything else, is in lockdown at the moment. 6 of the last 7 years saw me as an international trade advisor at DIT, and that was very interesting indeed. But although my remit is basically EU transition, let me just say that there are many reasons for optimism. I mean, it's the last thing we want is to feel that, you know, things are very bleak, because they're not. I mean, don't forget, we have 60 trade agreements in place, and we're moving very promptly on some other ones for US, Australia, and New Zealand. US maybe less promptly. Then we've got the Trans-Pacific Partnership, which, you know, could be an absolute wowie, because it'll also give us shortcuts to some of the countries I've mentioned already, and places like Malaysia, Vietnam, Singapore. So we are making headway. Above all, what I want to leave behind with you is the thought that you must please feel free to contact us. You know, pooling our joint knowledge and energy, I'm sure that we'll be able to get to the end of the transition and into this new dawn of trade with Europe and the rest of the world in pretty good form. Thank you very much. Can I have the next slide? So we have the contact links for service. There we are. So here it is. Just fill that in, send it back to us, and we'll try to get back to you ASAP. Thanks.
Thanks, Abe. I'll just hand quickly over to Mark now, if that's all right, and we'll keep the momentum going. Thanks, Abe, and yeah, over to you, Mark.
Morning, everybody. This will be challenging. It's I have a 5-minute slot to deliver a number of slides that usually take us in the region of anything from 45 minutes to an hour. So there's a challenge, and I don't mind that at all. My name's Mark Hampson. I'm an international trade advisor in the London and South East international trade team. So going to do a quick run through today of both the general DIT support, tell you a bit about who we are, how we're structured, and some specific EU transition support. So next slide, please. And again, thank you. So who are DIT? Formed in 2016, government department. Sorry, I've already broken the acronym rule, haven't I? So DIT, Department for International Trade, formerly UK Trade and Investment, UKTI, and for anyone like me old enough, before that, DTI, Department for Trade and Industry. Goal of the department is the promotion of British trade across the world. That's both export but also inward investment, although we specifically as trade advisors work on the export side of things. And we operate a number of services, or offer a number of services, to help British companies with that promotion of trade. So next slide, please. Thank you. So that's HQ, if you like. That's the global, that's the main structure. We then have a team of people like myself internationally, more than 1,300 staff in over 100 countries. Why that's important is that when we as trade advisors are talking about a particular market, we can't be, experts on all countries. We have colleagues that we can turn to talk about local market nuance, local market opportunity, how to do business, what the competition's like, etc., etc. Talking about the trade advisors, 200 plus of us actually across the country, but 60 specifically across London and South East. Next one, please. Okay, so who are the international trade advisors? Abe touched on this a little, and as I just said, over 60 of us across covering London and the South East. Our background is from industry, so we've all lived, worked internationally, either for large multinationals or indeed for our own companies. So we've felt the same pain, faced the same challenges and opportunities as most business opportunities. And what we actually do on a day-to-day basis, aside from very specific programs that we offer, is we're there as an advisory resource, someone to test an idea, Rob, pardon me for stealing one of your lines, but it's one of my favorites, somebody who will be a critical friend and actually tell you your baby is ugly or your product is ugly when you think that global domination is about to occur, really to stop you making that very expensive mistake. Backgrounds that we come from personally, 30 years in market intelligence, competitive intelligence. We have sector specialists across a range of sectors, from advanced engineering, aerospace, fashion, retail, food and drink, consumer goods. So we can offer a support for all types of companies. Market and region specialist, my background was very much the US and the Far East. Other colleagues, Middle East, or have lived and worked in Europe for many, many years. Also across different specializations, whether it's marketing, joint ventures, business development, sales, all manner of skill set is within the team. So next slide, please. Okay, so I'll cover this a little more. The trade services portfolio that we have now, I guess this sits there, in a general sense, but also dealing specifically with EU transition. We're calling upon, this whole toolkit on a daily basis. So initially, there's the one-to-one advice from the trade advisors that I mentioned already. We currently also offer an intensive trade support program, by which we will register you for the program, which involves then a diagnostic of your company, where you are at the moment, where you want to get to, and sort of highlights your strengths and weaknesses to give us some idea of where to focus and how to take you forward. We'll work with you to develop an action plan, and then for companies that meet the criteria, there is some funding available to help a matched fund towards specific projects that you might wish to undertake. Now, whether that's because of general growth or indeed to challenge or to take on a challenge that's been brought around by EU transition, or indeed the pandemic situation, whatever that may be, but we can help you with that. Market research overseas, as I said, through our international colleagues, is available, and historically, of course, we do an awful lot of activity around events, trade missions, attendance at trade shows, lots of workshops and seminars, face-to-face, in large groups of people. Well, we've been able to, thanks to the events people, who are also responsible for helping with some of this today, we've been able to pivot all of that into a virtual environment. So whether it's virtual trade missions, we've had meet the buyer events with international buyers. Recently, I was involved in some aerospace events out to the US. We run training workshops and seminars, things like managing agents and distributors, winning and delivering business, pitching and winning business, how to develop your social media presence, etc. So all of that, even in these sort of restricted times in terms of being able to get together. We've been able to make all that, when I say we, I'm going to really say that that's down to other people within the organisation. Our events management people have been able to switch that around so that we can still offer those services alongside the one-to-one ITA support. When it comes to the one-to-one support, I guess we're able to offer quite a range of support. And I suppose if you think about it, on one end as market development support, so helping you identify, enter new markets, offer new products into existing markets, all the way across to the troubleshooting that Abe talked about earlier. And a lot of our response and need from clients of late around EU transition has ranged from, how do I understand rules of origin? What is the VAT situation, which is with my concierge hat on, that's something for the VAT experts, to, how do I get my staff in and out of the country? Can I transit through a country to maybe go work on board a vessel or on an offshore wind farm, and how does that affect my 90 days out of 180 days that I'm now allowed in the EU? So all these questions, we're addressing on a daily basis from a variety of companies. And where our role will stop, and that we'll take you over to the EU, hand you over to the EU transition advisors, is where you need to get into a real detailed discussion. So if you want us to, and this is something we're doing all the time, sense check your understanding of a regulation, of a ruling, understand how to produce your commercial invoice, what information you need for your airway bill, whatever the case is, we can help with that. You need to dig deeper. You need a few hours of research. You need to speak to a number of specialists. We'll pass you over to the EU transition advisors, like my friend and former colleague Abe, who was speaking a few minutes ago. But really, there is just an extra resource to help you through the challenges and pitfalls that are there at the moment. So next slide, please. Let me just touch on this briefly. A lot of our customers that we work with work in an e-commerce environment. It's not my field, but if that's something that affects you greatly, we do have a number of specialists in the IT team, and both also at DITHQ, that can help you with that significantly. You'll have seen online a number of changes in that sales channel that need to be addressed. So again, get in touch with us if you need help on that. Next one, please. So some specific links to online tools. Firstly, there is the CHEG, as it's called, the how to export goods online tool. I point everybody towards that first and foremost. Answer a few questions about your company and your personal circumstances, and it will provide you with a checklist of issues to address. And again, then get in touch with us. We'll talk that through with you if you need to go deeper. Additionally, trade tariff tool, really helpful. Enter your harmonized code, enter the country that you want looking to export to at this time, and it will give you everything from rules, regulations, duties, tariffs, etc. Not just for EU, but outside as well. And there's also a link there to selling of services into the EU. Next slide, please. Couple of specific transition links that you may want to take a look at. Very helpful. Lots of good content there, and also our EU exit inquiry line, euexit@trade.gov.uk. Again, I'll just finish by saying, and next slide, please. All of these online tools, they are very helpful. They are very thorough. They're very in depth. But and this is something that is fed back to us frequently, you can kind of read too much, end up going round in circles, and that's when you need someone alongside to have a discussion with, have a chat with, and just sort of sense check the understanding. We're available to do that. We'll gladly do that with you. If we can't, between us, get a definitive answer. You know, there are other places we can go to escalate that issue, whether it's to the transition advisors, whether it's to networks of accountants, of law firms. You know, we'll be able to push you in the right direction. So that's me. Thanks for listening. I hope I managed to do that in the 5 minutes.
Thanks very much for that. A bit longer, but we'll give you that. We'll give you that. Just a couple of things to follow up on what Mark said, and Abe actually. Because these services are paid for through Solent LEP and essentially paid through by government, they're completely free of charge to the end user. So there are no charges for you guys if you choose to use those services. So the meter's never running, never will be. And the other thing is it's completely impartial. So because there are no fees exchanged and no agendas, as Mark said, we'll just tell it how it is and give you a very frank and impartial view on where you are and where you might want to go to. So thanks, guys. Thanks very much for that. We're now moving on to the next section where we've got our sessions with each of the individual experts from private sector organisations. And I'd really like to take this opportunity to thank the next 4 speakers for taking the valuable time out of their day to day to help with this. It's really, really appreciated. So thank you very much for that. And kicking off, we've got Jen Biddlecombe from Powers Smith. Powers Smith, the big firm of lawyers from Southampton. Jen's an employment law specialist. She's got 18 years of experience and a member of the Employment Lawyers Association and the Immigration Law Practitioners Association as well. So whether you're a small business owner or large national company, Jane works with clients to proactively manage their day-to-day employment issues and where possible try to avoid any protracted disputes and also to manage risks. So I hope that does you justice. Jane, over to you.
Thank you, Rob. Yes, lovely introduction there. Welcome everyone. As Rob said, my name's Jane Biddlecombe. I'm an associate at Powers Smith Solicitors in Southampton, and I specialise in employment and immigration law. Moving to the next slide. Thank you. So our agenda today, I've got about 15 minutes or so to talk to you about quite a lot here. So I've done some detailed slides for you so that you can take these away and refer to them later. But we're going to be covering these topics today. So firstly, employing EU nationals who you employ who are already in the UK, then employing new overseas nationals, including EU nationals. Becoming a sponsor, which we'll talk about later, and then just at the end we'll just touch on employing UK nationals within the EU. So moving on then to our first topic, employing EU nationals who are already in the UK. This will be under the EU settlement scheme, and under this scheme EU nationals have to have been living in the UK before the 31st of December last year. And then by the 30th of June this year, they need to apply through the EU settlement scheme to continue to live and work in the UK. So they'll either be applying for pre-settled status, which means that they will have been resident here for less than 5 years, or settled status, where they've been resident for more than 5 years. And settlement is basically means that they have an indefinite right to live and work in the UK going forward. New slide. So can we just move on to the next slide, Hannah? Oh. Okay, so I think we're on the right slide, yes. So existing EU national employees, so those who you're already employing, as I said, they need to register under the settlement scheme, but there's no need to do new right to work checks for these guys. So if they're already your employees, you don't need to redo those checks. But in terms of actions you can take as an employer, you really need to be reviewing your workforce if you haven't done so already, and identifying your EU nationals, and then asking them if they have applied under the settlement scheme. Hopefully they'll be aware of that scheme. And you just need to let them know that they do need to apply for settled or pre-settled status before the 30th of June. You can provide them with support with this if they need it, but it is a very simple system. You apply online, you have to prove your identity with a biometric passport, but then there's an automated check. So the individual will provide their national insurance number, and then there'll be an automatic check of HMRC records, which will hopefully prove their residence for the relevant period. If it doesn't, and the automated check comes back that it's not sufficient, then they can provide additional documentation to prove their residence. So you will need to keep an eye on this in terms of doing a follow-up check between now and June, because it will be potentially illegal to employ them after the 30th of June if they don't have settled or pre-settled status or some other right to work in the UK. So then moving on to employing new EU nationals between now and the 30th of June. This is kind of a transition period, so hopefully they will either have settled or pre-settled status, and this can be checked online. So unfortunately for settled and pre-settled status, there is no physical document which will prove that status. So they will get a letter from the Home Office confirming their status, but that is not sufficient for right to work checks. But the government has confirmed that up until the 30th of June, you still can accept EU passports or national ID cards for right to work checks for EU nationals. And just bear in mind, you can't demand evidence of settled status because there are discrimination issues there. But obviously, hopefully you'll have a good relationship with your employees where you can have a two-way conversation about this. If you're employing new EU nationals between now and the 30th of June, obviously there will be an issue about whether they were in the UK before the 31st of December. If they weren't, then they won't qualify for settled or pre-settled status, and they will need a skilled worker visa under the new points-based system, which we'll be going through in detail in a minute. So you just need to be aware that there is an offence of knowingly employing someone illegally. So, for example, if you know that this new employee doesn't have a UK address, then you're on notice that they probably weren't here before the 31st of December, and therefore they won't come within the EU settlement scheme. They will come within the new points-based system. If they were here before the 31st of December, though, again, you'll need to just remind them that they need to apply for settled or pre-settled status before the 30th of June. Okay, so just moving on now then to employing new overseas nationals, which will include EU nationals. Now, this is for your EU nationals who were not in the UK before the 31st of December, and they will need to be sponsored under the new points-based skilled worker visa system. You may be aware of the Tier 2 general visa system, which is what we had prior to the skilled worker, but that's now been replaced by skilled worker. We have still got the intra-company transfer visas, so that's where you're transferring employees from an overseas branch into the UK. So that can either be a straightforward intra-company transfer visa whereby you've got someone who's been employed in your overseas branch for more than 12 months, and that's unless they're paid over a certain level. And then there's also an intra-company graduate trainee visa for transfers to the UK as part of a graduate training programme for managerial or specialist roles. So that person would have to have worked for your overseas branch for more than 3 months. So we do have intra-company transfer visas still, but I'm not going to concentrate on those today. The main point that employers need to note going forward is that you will need to have a sponsor license to sponsor skilled workers or intra-company transfer visas, and there are minimum skill and salary thresholds which we're going to go through. So many of you who perhaps haven't had to have a sponsor license in the past are going to need one in order to sponsor EU nationals going forward. Now, there are other options which don't need a sponsor license, such as the new graduate visa that's coming in this summer, or new frontier worker permits for EU nationals who commuted to the UK for work before Brexit. But as I said, I'm going to focus today on the new skilled worker visa, which has come in newly in January. So in terms of what types of job can be sponsored under the new skilled worker visa, these eligible jobs are set out in Appendix Skilled Occupations, and they provide what we call a SOC code, a standard occupational classification code, and the going rate of pay for that role. And if you're familiar with the Tier 2 system, then the list of eligible jobs has been expanded significantly for skilled worker because the skill level has been reduced from degree level to A-level skill level. So examples I've just set out on the slide there: managers and directors in most areas, engineers, IT professionals, medical professionals, teachers, professional services and skilled trades. Just moving on then, in terms of the types of jobs that can be sponsored, some of those eligible jobs will also appear on the shortage occupation list, and I've set out some examples there. And the important point to note is that there is no visa route for low skilled workers going forward. This was discussed in the past, but it's not been proceeded with. So this could prove to be a real issue for some of you and for particular sectors, including construction and hospitality, which have traditionally relied on a large EU national workforce, and now will have to come within a visa situation where if the skill level is not sufficient to come within the eligible jobs, then there's going to be an issue. Moving on then to the actual points-based system. Can we just move the slide on? So hopefully that will catch up in a minute. So potential employees need a minimum of 70 points to qualify for this visa. So there are mandatory 50 points, which is a job offer from an approved sponsor, a job at the appropriate skill level, which will be one of those jobs on the eligible list, and English language skills also. Now, English language skills can be proved in a variety of ways. So you can be a national of an English-speaking country or have a degree taught in English, or you may have passed an approved English language test. But the remaining 20 points are related to salary, and this is the new tradable point system, which you may have heard of. So, new slide, please. Now, I've just set out on the next slide some minimum salary threshold examples, so you can see where these remaining 20 points may come from. So the minimum salary threshold is £25,600, or the going rate for the SOC code if that is higher. But there are opportunities to pay less than this in certain circumstances, because you can get your extra 20 points elsewhere. So, for example, if the job is on a shortage occupation list, or the individual you're employing has a PhD in a STEM subject relevant to the job, then the salary threshold is reduced to £20,480 per year, or 80% of the going rate. And another example is if the individual you're employing is a new entrant to the labour market. So if, for example, they're under 26, or they've been on the student route up to 2 years before their application, then again the salary threshold is reduced to £20,480. And the new entrant route is really designed to give younger people and those at the start of their career a helping hand. So for those of you who are familiar with the old Tier 2 general system, there has been a significant simplification of the system, which is to be welcomed. So as we've already discussed, the skill threshold has been lowered, so there are more eligible jobs that you can sponsor, and the minimum salary threshold has been lowered from £30,000. You may be aware also of the specific job advertisement process, which was called the resident labour market test, which you used to have to fulfil for tier 2. Now that has now been abolished, which is good news. So that used to require you to advertise a job in specific places for at least 28 days, so that you could see if there was a settled worker in the UK who may be able to do the job. Now, that caused significant problems in some cases where employers didn't know from the off that they might want to employ someone from overseas, and therefore their job adverts didn't comply with the resident labour market test, which meant that if they did identify an overseas national they wanted to employ, they would have to go through the whole advertisement process again. So that has now been abolished, but it is worth noting that you will still need to go through some recruitment process of some kind to prove to the Home Office that the job is a genuine vacancy, so not a sham job. Other changes from the tier 2 system, the old system, there's now no cap on the amount of visas that can be issued each month, which used to cause significant delays of a few weeks. And most visa holders can now switch to the skilled worker visa from inside the UK unless they're a visitor. So the simplification of the system applies to all new overseas hires. So it will be a lot simpler and quicker to recruit those from outside the EU than it was before. But in relation to EU nationals, obviously you've been used to free movement where there hasn't been any visa obligations at all. And therefore for EU nationals, it's going to be a lot more complex to recruit than the experience that you've had before Brexit. So as I said earlier, if you want to sponsor someone on a skilled worker visa, then you will need a sponsor license to employ new overseas nationals, which will include all EU nationals going forward. So the process is that you apply and get a sponsor license, and then you apply for what's known as a certificate of sponsorship for the individual, and that's just a reference number which that individual then puts on their individual skilled worker visa application to prove that they've got a sponsor. Now, becoming a sponsor, it does involve onerous duties and responsibilities. It's a position of trust where you're the kind of first line of defence in terms of immigration control, and therefore it's taken very seriously by the Home Office, and you can be subject to compliance visits from the Home Office. I'm just going to run through very briefly the sponsored duties, as these are quite detailed, but in terms of the kind of categories of duties, you have a duty to keep certain records, and they're set out in Appendix D. You have a duty to report certain things. So, for example, you must report if an employee's gone AWOL, or that their job title or their salary has changed within 10 working days. You have to comply with the law, and that's not just immigration law, that's all areas of law. You must prove that you've got a genuine vacancy, as I was saying before, and you do have a duty to cooperate with the Home Office. Now, it is important that before you apply for a sponsor licence, you put the appropriate HR systems in place for your, sorry, can you go back a slide? The appropriate HR systems in place to basically prove that you're complying with your sponsor license. So you have to monitor right to work checks, you have to keep relevant documents, as I said, under Appendix D, you have to track the attendance of your employees and keep contact details up to date, and as I said, report if there's any problems. You also need to appoint people within the business to manage the licence and take responsibility for sponsor duties. So this includes what we call an authorising officer, who is usually director level in your business, and that's the person that has overall responsibility for your sponsor licence. You then have what's called a level 1 user, who basically does the day-to-day management of the sponsor licence, applying for certificates of sponsorship, etc., on what we call the SMS system, which is the sponsorship management system. So your authorising officer and level 1 users will be subject to criminal records and security checks during the sponsor licence process. Next slide, please. So applying for a sponsor licence. This is an online process, so you apply online, and I put out the website link there. You then have to email your submission form signed by your authorising officer and your supporting documents within 5 working days. It generally takes 8 weeks to get a licence. There is a new priority service that you can pay for, which you pay £500, and then you get a decision within 10 working days. But you're not guaranteed to be able to take advantage of that priority service. There are limited numbers each day, limited to 10 applications per day that can be priority, and it's on a first come, first served basis every day. And that licence will be valid for 4 years, and then you need to renew it at the 4-year stage. Next slide, please. So in terms of applying for the sponsor licence, you need various documentation. You will need a detailed covering letter with the specific information required by Appendix A. You'll need to provide, for example, a hierarchy chart and details of the roles that you want to sponsor. And then you will have to supply at least 4 supporting documents, which effectively to prove that you're a genuine business. There are specific requirements for some businesses as well. So if you're a startup, so you've been trading for less than 18 months, then there are further requirements for franchises and also for those who are subjected to regulations by a regulatory body. The important thing to note here really is that you really must get this process right, because if your application is refused, there is no right to appeal, and then you can't apply again for another 6 months. So this could have big consequences for your recruitment if you make a mistake in your application or you don't send the correct supporting documents. New slide, please. Thank you. Excuse me. So there I've just set out the cost of sponsorship for you. So the actual cost of a licence depends on whether you are categorised as a small sponsor or a medium to large sponsor. And you're usually a small sponsor if 2 out of the following apply. So your annual turnover is £10.2 million or less. Your total assets are worth 5.1 million or less, or you have 50 employees or fewer. There's also an additional cost in terms of the immigration skills charge, which is something that has to be paid per sponsored employee per year. So that's £364 for a small sponsor and £1,000 per sponsored employee per year for a medium or large sponsor. And each certificate of sponsorship for the employee that you wish to bring on board costs £199. New slide, please. So really the key actions to take now, as we've been through, firstly, to review your EU national workforce that you currently employ. They should be in the process of getting pre-settled or settled status right now. So, you need to be on top of that so that that's all done by the 30th of June. And then secondly, to review your recruitment needs for this year and consider applying for a sponsor licence if you think you will need to recruit new overseas nationals, including EU nationals, this year or going forward. And just moving on to my last slide then, I did say I was going to touch briefly on employing UK nationals in the EU. Now, UK nationals will need a work permit to work in an EU country going forward, unless they lived and worked there prior to the 1st of January. So in that case, it's each EU country has a scheme equivalent to the UK's settled status scheme, which protects their rights. But if people arrive in the EU country to live and work after the 1st of January, then each EU country is going to have its own requirements for work permits, and therefore you will need country-specific advice in relation to the country where your employee is. And just to go back, actually, I meant to make the point in terms of the EU countries equivalent to the settled status scheme. There are the actions required in each EU country, and the deadline varies from country to country. So you need to be on top of that. For example, some EU countries have a kind of automatic system where no action is necessary, whereas some have more like the UK system where you have to apply for status. But as I said, if people are arriving after the 1st of January, then they will need a work permit. And it's also worth bearing in mind that if your employee works in an EU country, then you will need to apply and follow the mandatory employment laws of that country. So that could be in relation to pay or holidays or dismissal law. So that was just touching briefly on employing UK nationals in the EU, and that's really all I wanted to speak to you about today. Obviously, you have the detailed slides there, but if anybody does have any queries in the future or that are not covered by any questions today, then please feel free to contact me on the details that I put on my first slide. But I'll pass you back to Rob now and on to your next speaker. Thank you.
That's great. Thank you very much, Joan, and thanks for your time. Really good stuff. And I'm sure there'll be plenty of questions in the follow-up. So next up, we've got Laura Trapnell from Paris Smith. So Laura's been specialising for 25 years in intellectual property, or IP, I'm sure we're going to call it, but I think we all know what IP is. So working in contentious and non-contentious areas of intellectual property law, and spent many years at niche intellectual property firms and teams in London, and joined Paris Smith back in 2012 to head up the team looking after that area, and also the IT team as well. I've got a problem with my mouse, Laura. I don't know if you can have it. No, just kidding. So Laura also sits on the panel of advisors for the local Catalyst Centre in Southampton, if you know about that, and also for Somerset, advising Catalyst members on their intellectual property, from ownership issues, strategy, protection, and also enforcement, not just in the EU, but presumably around the world as well. So with that, I'll hand straight over to Laura and hear more about that. Thank you.
Thanks, Rob. Morning, everyone. Yes, my name is Laura Trapnell, and I'm the Intellectual Property and Information Technology Partner at Paris Smith. And I'm going to talk to you today about how Brexit has affected both of our intellectual property and also our data protection regimes. So the really quick answer is, at the moment, in reality, there's not very much change for either. There are some technical and legal changes, but generally it's business as usual. Having said that, for those that would like another 15 minutes on this topic, I'll go into a little more detail. 15 minutes isn't very long at all to cover both topics, so it's a little bit of a whistle-stop tour, I'm afraid. Next slide, please. So intellectual property rights are largely territorial. They must mostly be registered in order for them to be enforceable, and you must register in the territories in which you want to be protected. Now, for many decades, we've operated within a harmonised IP regime within the EU. Post-Brexit, we're no longer within that regime, although we are still bound by some of the international treaties like TRIPS and WIPO. Of all the intellectual property rights, international trademark practice and registered designs are likely to be the most impacted by Britain's leaving the EU. The impact of Brexit on our national trademark registration system will actually be minimal, and we continue life as usual within the within the UK and our own Intellectual Property Office, or IPO. In respect of international trademarks, we have two ways of protecting them. The first is as an EU trademark, which protects the whole of Europe in one application. And the second way is via an international registration, or an IR, under the Madrid Protocol system, whereby we choose our international territories and hop around the world in terms of protection, replicating an existing base trademark registration. So for both EU trademarks and IRs, trademarks that are already registered before the end of the transition period have already automatically been granted a comparable UK registered trademark for the same sign and covering the same goods and services. The filing date of this comparable UK trademark is the same as that of the EU or the IR trademark on which it is based. So essentially, we end up with an EU or an IR registration and also an identical UK registration. In respect of pending EU and IR trademark applications that were not yet registered by the 31st of December, going forward, these applications fall away, and we now have a period of 9 months from January 2021 in which it's possible to file a separate identical trademark application with the UK Intellectual Property Office, paying additional fees, and claim the filing date from the prior EU or IR application that was still pending at the end of the transition period. For clients using large firms of trademark attorneys which have offices based in the EU, clients can continue to be represented in the EU by their existing trademark attorneys. For clients with attorneys based solely in the UK, we have now lost representation rights before the EU IPO, and this means that we need to treat the EU as we would do any other international territory and instruct local agents. This is something that we're all very used to doing, and in practice, the only impact will unfortunately be on costs. I thought it was worth mentioning that in respect of unregistered brand names, the common law right of passing off, which is where you assert that you have a reputation under a particular name and that a third party is trading off that reputation, this remains unaffected by Brexit because it's a national common law right. Next slide, please. So designs are complicated things. There are two very separate systems, one in the UK and one in the EU. And within each of those systems, there are two different regimes. The first for registered designs, which must have eye appeal, so no ugly products that Mark mentioned earlier. So they must have eye appeal, and registered designs protect the appearance of the whole or part of a product. And then the unregistered design regime, which arises automatically and protects the shape and configuration of the whole or part of a product. So as with trademarks, the UK national design registration and unregistered design rights systems will be largely unaffected by Brexit, and we continue life as normal. However, the registered community designs and the related unregistered community design right are both governed by EU regulation and are affected in a similar manner to trademarks. So if you had a registered community design that had been registered already by the end of the transition period, this has already been granted an equivalent UK national registered design for exactly the same design. In respect of any applications for registered design which were pending at the end of the transition period, again, you have 9 months from January 2021 to file the corresponding identical design application with the UK IPO. Holders of an unregistered community design right, which arose before the end of the transition period, have in a similar manner automatically become the holder of an equivalent UK unregistered design right, which affords the same level of protection. So next slide, please. Copyright is and always has been a national right that each country provides separately and independently, and therefore our UK laws on copyright remain unchanged. However, copyright at an international level was largely harmonised by a number of international treaties, and despite Brexit, this will also remain unchanged. Therefore, the majority of copyright works, such as books and films, photographs, drawing, online content, music, all of those will still be protected in the EU because of our continued participation in the international treaties on copyright. And this applies to works made both before and after the 1st of January 2021. Next slide, please. So basic patent law in the UK hasn't changed following Brexit. The UK Intellectual Property Office will also continue to grant UK national patents just as it always has done. The position in the EU also doesn't change with regard to patents. The UK continues to be a contracting state to the European Patent Convention, the EPC, which is the international agreement that established the European Patent Office, which itself oversees the examination and grant of European patent applications. So the EPC is entirely separate from the European Union and has about 40 contracting states, including all the EU countries, but also including many non-EU ones, and now the UK. So the existing patent litigation system will also continue as before. The only thing that will be impacted with regard to patents is the proposed Unified Patent Court, the UPC, which is not yet up and running. And although the UK had previously ratified the UPC agreement, now that we've left the EU, we have withdrawn from this and will no longer be able to participate in it as and when it comes to fruition. Next slide, please. So in terms of legal practicalities, I've already said that intellectual property rights are territorial in nature, and following our departure from the EU, the courts of the UK will continue to have jurisdiction on issues of infringement and validity of IP rights covering the UK only. We will no longer be able to litigate or question EU IP rights in the UK courts. For litigation commenced in the UK on or before the 31st of December 2020, but which is not yet concluded, both the Brussels and the Lugano regimes, which covered service of proceedings, jurisdiction, and enforcement of judgments between the UK and the EU and the wider EEA, those will continue to apply until the conclusion of that particular litigation. However, generally, from the 1st of January this year, both Brussels and Lugano regimes have been replaced by our common law. Our common law regime is already well established, governing service of proceedings, jurisdiction and enforcement between the courts of the UK and other non-EU EEA countries like the USA, and we will now simply extend this to the EU and the EEA. So what do we need to think about from a contractual point of view as far as intellectual property is concerned? Licenses of IP rights, which were in force on the 31st of December 2020 and which authorised acts in the UK which would otherwise infringe an existing IP right, those will continue after Brexit to authorise those acts in respect of the extracted comparable UK registrations. Going forward, thought should be given with regard to territorial scope of IP licenses, now that it's possible to separate the UK and the EU. So we will be able to grant licenses separately in the UK and in the EU of intellectual property rights, presumably on different terms, in a way that we've never been able to do previously when the whole of the EU was counted as one. In terms of jurisdiction clauses, the UK's withdrawal from Europe and the corresponding treaties will make it easier, in theory, for customers to attempt to litigate in their domestic courts. So in order for us to avoid this scenario, it's really important that we include an exclusive jurisdiction clause and an exclusive law clause, both in favour of England in our contracts, unless we have very good reason not to. Given that the UK has now left the single market and the position with regard to the doctrine of exhaustion of IP rights and parallel imports has now also changed. Exhaustion of rights meant that the placing of goods on the market in any EEA country by the owner of the relevant IP right in those goods or with their consent under license, doing that generally exhausts the owner's ability to enforce their IP rights in those goods to prevent resale anywhere else in the EEA. This makes total sense. It basically prevents artificial trading borders within the EEA, which are based only on IP rights. So despite Brexit, in the UK, we will be maintaining that existing exhaustion of IP rights regime. But if this is no longer the position in the EU, and as from the 31st of December 2020, the owner of an IP right in the EU or EEA countries will be able to enforce such rights to prevent import into the EU or EEA of genuine goods placed on the market in the UK. Next slide, please. So I've been asked to say a very quick word on .eu domains. You can only register or hold a .eu domain if you are an EU citizen, independent of your place of residence, or if you are a natural person who is not an EU citizen but who is resident in a member state, or if you are a commercial undertaking or organisation that is established in the EU. This means that as of the 1st of January this year, many UK companies with a .eu domain may no longer be able to access or use them, and we can certainly no longer apply to hold one. There doesn't seem to be a transition period. However, the withdrawn domain names will not be available to any other party for 12 months, during which time the original owner can reapply to be reinstated if they subsequently meet those eligibility criteria. I think it's worth remembering the power of registered trademarks versus domain names. It's not cost effective for businesses to register domain names all over the world, and a registered trademark in a particular territory can often see off cyber squatting domain names within that territory. So as part of your intellectual property strategy, be thinking about the positioning of registered trademarks if you are also worried about cyber squatting. So moving on to a whistle-stop tour of data protection changes. And that's the next slide, please. Thank you. As we know, the rules which govern the collection and use of personal data have been set at an EU level by the GDPR. In the UK, our own Data Protection Act 2018 incorporates and supplements those standards set out in the GDPR. Following Brexit, there is no immediate change in our own data protection standards. This is because the Data Protection Act 2018 will remain in place, and GDPR has been amended and incorporated into UK law to sit alongside it, and we now refer to this as the UK GDPR. Post-Brexit, the free flow of personal data from the UK into the EU is largely unaffected. This is because all of the EU countries have adopted GDPR and so already have what is known as adequate standards in respect of the safe and proper processing of personal data. However, the real impact of Brexit on data protection is felt the other way round by the transfer of personal data into the UK from the EU. EU organisations are only permitted to transfer personal data outside of the EEA to what is known as a third country, if there is a legal basis for doing so. Since the start of this year, the UK is now a third country. So the UK has already asked the EU Commission to provide a decision that our data processing practices and legislation are adequate, because for the last 3 years we've been abiding by GDPR and we will continue to do so. The EU and the UK have agreed an interim period for the free flow of personal data to the UK for 4 months, extended by a further 2 months unless one of the parties objects, or if earlier there is the adequacy finding granted to the UK. So essentially we have now a maximum of 6 months where things don't change and within which the EU needs to grant us an adequacy decision. During that time, data protection transfers between the UK and the EU continue as normal. If the adequacy decision is granted during this time, then all is well and we continue as we are. If there is no adequacy decision during this time, we will have to implement an alternative legal basis for the transfer of personal data from the EU into the UK, and we will do this using standard contractual clauses, which are the model EU approved data protection clauses. Next slide, please. So from the 1st of January, UK-based organisations must, in certain circumstances, which I will go on to explain, appoint an EU-based data protection representative to represent them in data protection matters in the EU. This is required under GDPR. Your representative, who can be an individual or an organisation, will be your point of contact in the EU and will be responsible for facilitating communication with your EU data subjects, maintaining your record of processing activities in the EU, and receiving communications from the EU supervisory authorities. Both data controllers and data processors must, unless an exemption applies, appoint an EU data protection representative if you are based in the UK and don't have a branch or an office in the EU or EEA, but you either offer goods and services to individuals in the EEA or you monitor the behaviour of individuals in the EEA. If you fulfil all of those criteria, you must appoint an EU representative. And remember that if you are appointing an EU representative because you deal with personal data of individuals in the EEA, then you must also comply with EU GDPR in respect of their personal data. So the exemption is if you are a public authority, or if your processing of data of EU nationals is only occasional, and please be aware that the interpretation of this is very narrow, or if it's low risk to the individuals concerned, or if it doesn't involve large-scale use of special category or criminal offence data. So those are the exemptions. If you do have to appoint an EU representative, it needs to be based in a country where your processing activities are taking place. So if you are processing in France and in Spain, then your EU representative must be in one of those countries, but it only needs to be in one. You can appoint one only for the entirety of the EU. There's no specific contract, but your appointment should be documented in writing. And of course, you must then update your privacy notice with the details of the EU representative to tell data subjects that one has been appointed and who it is. Typically, the best way to do that is to include information on your website. And there, I think probably over 15 minutes is my whistle-stop tour of Brexit impact on IP rights and EU data. Thank you.
Great, thanks, Nora. Thanks very much for that. We are running a little bit behind, so I'm going to jump straight on over to Louise over at Fragerman now. So Louise is one of the partners with Fragerman, who are a global immigration law firm, and she's been based in their team now for a while. And Louise has been at the forefront of the company's Brexit offering and advised a lot of SMEs and micro businesses on their Brexit strategy with regards to the movement of people and preparing them for the new regime, as it were. So, Louise, over to you.
Thank you very much indeed, Rob, and thank you for inviting me to be here today. So as the slide says, my specialism is UK immigration, but I'm here today with something of a European hat on, so I'll do my best to cover travel from both a European and a UK perspective. So if I could have the next slide, please. Just the first thing that I was going to mention was around the setting of the scene. Obviously, one of the potential drivers for Brexit was around the free movement of people, and it became quickly apparent that that was going to be removed with the withdrawal agreement. And what that meant, of course, was that Europeans who were in the UK were able to stay, and the same was true for UK nationals who were in Europe. And all throughout the transition period, individuals that arrived in the UK or in Europe were also able to obtain those rights. But of course, from the 1st of January, everything changed, and UK nationals who travel to Europe are now third country nationals, and the same is true in the vice versa scenario. Now, one point that I did want to make, one, because it's important, and secondly, because my colleagues in our Dublin office get very cross when I don't, is that none of this actually applies to Irish nationals who are able to come and work or travel freely to the UK, and the same is true to British nationals travelling to Ireland. Now, when we're looking at who this impacts, I found it very useful to break it down into these three categories. So first of all, your population, so those Europeans that you employ in the UK or UK nationals that you employ in Europe. And Jane very eloquently covered the EU settlement scheme that those EU nationals in the UK need to apply to before the end of June. Secondly, of course, your new hires, so hires from the 1st of January. From a UK perspective, that means that you would need to sponsor them potentially under the new immigration regime, and also your UK nationals in Europe. If they relocate from the 1st of January onwards, they are going to need a work permit to allow them to do whatever it is that they're going to do. But there is this third category of individuals, so not where you're sending people necessarily to one country or another to be based there, but your business visitors or potentially your frontier workers. Now, it seems a bit strange actually to be talking about business travel at the current moment in time, given that the world is facing big issues and we can barely leave our own front door, let alone travel overseas. But I do think it's a really good opportunity for companies to think about their business travel strategy, to get ahead of the game and to get in front of the people that that need to know, and so that they can put any relevant contingencies in place. So we could just flip to the next slide. Thanks. So as you'll know, the removal of free movement means that UK nationals in Europe and Europeans in the UK are now third country nationals. So they're treated when they travel, or when a UK national travels to Europe or vice versa, as if they were a US national or a Canadian or a Japanese national. Now, one important point to make is that there are no visas required for those individuals. You'll just need your passport. At some point in time, probably in 2022, there is going to be a European travel and immigration authorization system, which will work a little bit like the US ESTA system. So not a visa process, but an online form that you will need to submit a couple of days before you travel. But the important point, I think, around becoming a third country national is really the mindset change that we're all going to need to have when we travel to Europe, or if you're European traveling to the UK. So probably never before in our sort of recent history have we had to consider what it is that we're going to do when we travel to a European country. And if we look at that in reverse first, so if you are a European national and you're going to come to the UK as a business visitor, you're going to need to ensure that the activities that you want to perform are permitted by the UK immigration visitor rules. Now, as a broad brush, if you're coming for meetings, that will be fine. If you're going to do some training, you're probably in a grayer area. And if you're going to do productive work, that's pretty much a no-no. But I think it's about getting in front of those individuals and explaining they're going to need to think about what it is that they are doing and think about whether or not that's permitted. And if it's not, whether or not they need work permission. Or the alternative, of course, is whether they can change those activities slightly so they bring themselves within the visitor regime. Now, for UK nationals going to Europe, the situation is probably even more complex. So the activities are actually determined by the destination country. So they may find that they can go to one country, say they go to France and they're permitted to do something, but if actually they wanted to go on to Croatia or Romania, those same activities may not be permitted. Now, obviously, the Trade and Cooperation Agreement does go some way to try to do something about standardising some of those activities, but it's not been implemented into national legislation as yet. It certainly won't go the whole way to making activities standardised across the EU. So really careful consideration needs to be given to the activities that a UK national is going to do in any given country that they're travelling to. And the second important point for those UK national outbounds is around the amount of time that they're able to spend in the Schengen area. So they're only allowed to spend 90 days in every 180 in the Schengen area. And that not only includes their business travel, but also their travel for tourism and for leisure. So I think you can imagine a scenario whereby an individual tries to go on their summer holiday and realizes they've actually used up all of their Schengen allowance during their business trips and probably won't go down so well. So again, really important that these messages are communicated. Now, in terms of what we can do in ensuring that business travel runs as smoothly as possible, it is highly recommended that you have 6 months on your passport before you were to travel into Europe. My husband actually reminded me of this earlier this week and said, was I aware that you needed 6 months on your passport before travelling to Europe? And I gave him my best condescending look and reminded him what I did for a living and promptly ran upstairs to check all of my family's passports. So I can imagine that business travellers will want to do the same as and when, of course, things start to open up in a hopefully post-COVID world. But I think it's also important to think about who it is that we need to get in front of. So it's not just, of course, your traveller population. It may be that you have commuters who work across various jurisdictions. Have they established enough rights to be able to get a frontier worker permit in somewhere where they don't live? Or do they need a work permit in their destination? One important point about those UK nationals who are living in Europe, and when they apply to the equivalent scheme to the EU settlement scheme, they only gain their protected rights in the country in which they reside, not necessarily in the one that they live in. So if you do have individuals that work cross-border in Europe, again, that's something that you need to give some thought to. And then the third cohort of people that I think it's worth giving some thought to is around remote workers. And I obviously mention this in the context of what has happened in the last year, that you may have received requests from individuals to work in countries other than which their contract of employment is. And if you do have any individuals who are working in a country of which they are not a national, again, you may need to look at them as to whether or not what they are doing is permitted, either as a business visitor or whether or not they need to establish some form of residence to be able to obtain a protected right or indeed a work permit. And then lastly, how can we deal with these individuals? What is it that we could be doing? So firstly, I think the first recommendation is, of course, to communicate with them, identify who it is that you're talking to. Now, if you are in a relatively small business, it may be you know exactly who those individuals are, and you can go and have a conversation with them and say, I know that you travel regularly into Europe. Are you aware of all of these requirements? Have you given that thought? Can I help you with understanding what you are able to do in any given in any jurisdiction? It may be that you actually need to do something which is a bit more of a mail shot. So it might be that you have a video to promote what the issue is, or a help sheet. It may be, if this is something that people do very, very, very regularly, that you need to look at the business traveller tools, something that can assess whether or not an individual is able to do what they're going to do before they travel. So rather than waiting to hear about it later, because the last thing, of course, that you want is an individual who is stuck at immigration control and unable to enter Europe, or indeed the UK, because their activities go beyond what is permitted in that given jurisdiction. Now, in terms of making that travel smooth, there are a few things an individual could carry with them. I'd say this is rather belt and braces for UK nationals travelling into Europe and vice versa, but it may be something that you want to consider. So an invitation letter from wherever it is that they're going, a travel itinerary, proof of health insurance, proof of their available funds. It could be a bank statement, etc. If we could move on to the next slide. Thank you. But of course, there are permissions for individuals who have been performing these sorts of activities, so commuter activities, during 2020 or potentially before. Now, in the UK, there's a frontier worker permit that was announced. It's only been in action since the 10th of December. Now, in order to qualify for one of these permits, an individual must, since the 1st of January, or sorry, I should say 2020, be an EA or Swiss national. They must not be primarily resident in the UK. Now, that's usually assessed by not having been in the UK for more than 180 days in the previous 12 months, and also that they can establish that in the last 12 months they have been a worker or self-employed, or have some form of retained right. Now, with those frontier workers, they're able to submit an application much in the same way as the EU settlement scheme that Jim referred to earlier, so quite a light touch application submitted with a selfie and an online form, although there are a few more documentary requirements. And they will get a digital permission. Now, these permissions aren't going to be required until the 1st of July, but certainly now is the time to start identifying whether you have any of these commuter individuals who would benefit from getting this permission. Now, certainly what I've seen from the businesses that I work with is that they had already identified this population, and actually they've gone and got them a status under the EU settlement scheme in any event, because the residency requirements are pretty low in terms of qualifying for that particular scheme. So you may find that many of them have already obtained themselves a status and actually don't need to go and get frontier worker permits as well. But if you do have commuters, it certainly is worth speaking to each of them and seeing whether or not they're able to qualify under this particular category. So Rob, I've tried to go as quickly as possible and save some time, and I hope that was okay.
That's great. Thank you, Laura. Thanks very much for that. And last but very much not least, we've got Klaus Anderson from Royds Whitty King. So Klaus is one of the partners at the firm, looking after their commercial team, deals with all aspects of corporate and commercial work. So Klaus is going to give a more general view on the EU transition implications. And if you do have any questions for Klaus, can you please be gentle with him, because I understand it's his birthday today. So over to you, Klaus.
Well, thank you very much. Thank you for that introduction. Yes, it is. So if I can have my first slide. So what I wanted to talk about here is basically first the effect of Brexit, the new trading relationship, and a bit about import and export to and from the UK. The area in itself is huge, so one could spend a whole day talking about it, so I can only give a brief overview. The actual trade agreement between the UK and the EU takes up around, I think, 1,250 pages. So it's quite a lot. Can we have the next slide? Yeah. One of the aspects I think that sometimes is not necessarily forgotten, but one of the things that I think many businesses should think about is what the effect of Brexit actually is. If we look at what was the until January 1st this year, what was the main pillars for Brexit, sorry, for EU membership, what was the main advantages? It was the free movement of goods, services, capital, and labor. And the UK was member of a customs union. All that facilitated a frictionless trade. So in the olden days, you wouldn't necessarily have to worry that much about sending goods from let's say, the UK to Germany. Now that has disappeared, and that means that the UK is no longer, as we all know, a member of the EU, and is no longer a member of the customs union. And that means that the UK is a third country in relation to the EU. Therefore, the important question is, without the free movement, how does that impact your business? And if it impacts your business, how do you work around it? And I think the important part is as well to understand that it will impact businesses in a different way. So what applies, what works for one business may not necessarily work for your business. Can we have the next slide? So as we've heard a lot of it today, the EU-UK Trade and Cooperation Agreement replaced, so to speak, the implied trade agreement with the EU membership. The agreement that preceded this agreement, the withdrawal agreement from back in 2000 and early 2020, what that did was only to sort out the exit of the EU. It did not, in a particular great detail, deal with the trading and the relation going forward, save for particular aspects in relation to IP and citizenship, etc. So the trade and cooperation agreement is really the basis upon which the UK businesses deal with businesses in the EU. And the first item to focus on is that it secures a tariff-free and quota-free trade. So what that means is that as a starting point, neither the UK nor the EU as such are entitled to collect any tariff on goods moving. That does not necessarily imply that there aren't any other levies, but tariff in the free trade agreement sense are not paid. Also, there are no quotas, meaning that UK exporters can export as much as they want to the EU. A second item which is very important to focus on are the rules of origin, because the free trade agreement applies to goods that are either produced in the EU or the UK. So goods produced in the UK will benefit from the tariff-free trade to the EU. Likewise, goods produced in the EU will as such benefit from the tariff-free trade to the UK. Now, there are in the trade agreement quite complex rules about how you make up the rules of origin. Very rarely goods are just produced in one place, but may consist of items, products from many other countries. And I think it's a bit outside the scope of this seminar to go into detail with it, but I think it's very important to note that there is this issue, and I think it's important to make sure that in the export from the UK, that one put together the documents which are necessary to prove the origin of the goods. A third item which is also quite important is the sanitary checks, what's sometimes referred to as SPS checks. These are health checks that takes place at the border, other checks that basically the goods comply with certain standards, and this is again a reflection of the fact that the UK has now left the EU. That's why one cannot necessarily assume that goods produced in the UK under UK standards will automatically be able to be put on the market in the EU. That is one of the reasons why there are checks to certify that the goods can be actually sold those places. The important aspect of the treaty is that it does not provide for mutual recognition. What it does, it sets up a framework consisting of what one could call minimum standards based on which the UK and EU will practice those SPS checks and those provisions. And that leads into the final item on the slide. There could potentially be no, we need to stay on the previous slide, so we should just stay there. Thank you. So in relation to technical barriers, the free trade agreement recognizes that such may exist between the trading blocs, but what the free trade agreement does is that it provides for rules within which both the EU and the UK can practice and basically live with such trade barriers so they do not unjustifiably prevent trade. And without going into further detail, the same applies to the customs cooperation. There are rules in the treaty that secures that the custom authorities on both sides of the channel cooperate in relation to the trade going forward. And now we can jump to the next slide. So, having looked at the trade and cooperation agreement, we will now go to some basic rules about import and export. So, looking at it from the UK side, until January 1st this year, the UK was applying the EU's common external tariff schedule when when businesses imported products from overseas. And we are not talking about products that came from the EU. It could be products that came from countries that the EU did not have a free trade agreement with. So again, as a reflection of the UK leaving the EU, the UK has adopted its own global tariff system. It will apply to goods that comes from countries with which the UK does not have any free trade agreement with. So that is obviously not the EU, but it could be countries like the US, India, Brazil, China, and Australia. And what the code does is that it simplifies and harmonizes some of the tariffs. It in many respects makes it a bit easier than it used to be. It takes away some of what sometimes we refer to as nuisance tariffs. And it has actually in many areas lowered the tariffs that importers otherwise would have to pay. I mentioned bilateral trade agreements, and again, as a reflection or as an effect of the UK leaving the EU, the UK has had to negotiate a number of trade agreements with countries that do have a trade agreement with the EU, but as an effect of the UK leaving the EU, the UK has had to enter into bilateral trade agreements. Those, I believe, the UK has negotiated around 63 of those. One of the more sort of famous of the agreements, the ones with Switzerland, with Norway, and also it was quite publicized the trade agreement with Japan, which, as we heard earlier today, also perhaps opens the door for an application to the Trans-Pacific trading partner system. Next slide. And what I should say as well too, which is very important in relation to import and export, it is also important in this situation to secure that the goods that you either import or export, that you got a certificate of origin, because many of those free trade agreements, and it's not just the UK EU trade and cooperation agreement that has those requirements, but basically most, if not all, trade agreements will have a requirement that in order to take advantage of the preferential tariff system, the goods traded must have a certificate of origin from the treaty country. On my last slide, I wanted to highlight a few practical considerations. Again, as an aspect of the UK leaving the EU, goods manufactured in this country, you cannot necessarily rely on them being able to be sold in the EU. That's why it is very important to consider license, whether there is a license requirement, whether the standards for the product complies with the destination country's standards. Also, more widely, if it's a consideration to set up a business in another country, one may need to look at whether you need a license to carry out such activity in the destination country. If you don't have what is commonly referred to as a URI number, I think you should try and get one. It is a necessity in order to export. Practically, you can get one online on gov.uk. Another aspect which I think has surprised a lot of people, and something that we clearly need to get used to, is that there are more forms to fill in. So you need to focus on making sure that you fill in the right declarations, the right export and customs declaration. And my final point is planning. Plan your import, plan your export. And I think that's sort of a common thread in everything we've been talking about this morning. It is really, really necessary for businesses in the UK to plan their activity, how they wish to export, how they wish to import going forward. It's probably always been a necessity, but it's even more important now. And again, obviously feel free to contact if you've got any questions in that regard. It relates to contracts, it relates to corporate structures, so there are many aspects that one need to think about. And that concludes my presentation.
That's great. Thank you very much, Klaus. So we're just going to change the format a bit now, because we are up against time. I've been appalling at keeping speakers to time. I'll take full responsibility to that. We have had just a few questions. There aren't that many, and they are quite specific. So what we'll do is, to those people who've asked those questions, we'll just go back directly. So we'll allocate them to relevant, one of the relevant experts, and we'll just revert directly to those people, if that's okay. So we can wrap things up now. So this, the whole issue around EU transition tends to centre on the three main areas that Klaus mentioned. So logistics, so movement of goods and services around, taxes and tariffs, and people. And I think it's fair to say in this session we've focused primarily on people, but in forthcoming sessions that we have planned, which you'll see identified on the screen now, we've got a number of other sessions planned where there'll be more detail on the more mechanical side of the process, and some industry specific content as well around maritime and engineering as well. So that just leads me to thank a few people. So thanks for the organisers, thanks to Hannah and Harriet for putting it all together, thanks to Solent Lep and Jane for funding the programme, and for all of their support. Thanks to all of our expert speakers. Again, thank you so much for taking the time out of your valuable days. It is really appreciated, and I think I'd like to say that on behalf of all of the participants today. We will send you contact details of all the relevant people after the event, along with the details of the next events we've got coming along. And then last but not least, a big thanks to all of you for attending and taking the time out of your business day. You know, we appreciate it. It is a pretty testing time for all of us right now, but particularly if you're running a business, so it is appreciated. And finally, happy birthday, Klaus. And we look forward to seeing you at one of the future events. Thanks and goodbye, everyone.
Thank you.